to another episode of the Legal Tumble podcast. My name is Lucas Mongi, and with me I have small Daktari Mutedia Kenson. You can say hi to the listeners of our podcast.
Hello, listeners. It's good to be back again to have this legal tumble.
I think go falling through the vortex of Kenyan issues anyway.
Yeah,
Okay, thank you so much, Kenson, for joining us today. Uh, the contributions are always really like so. Of course, we have been away for a while. We have been very busy with many things. So,
in a
but we're back
minute.
today. We have so many things to cover today. There are so many things which have been going on, which are which have some legal ramifications in our country. So we want to rush through them because time is limited, and there are so many things to talk about. Anyway, there's so many
For
things that
sure.
we want to cover today, and we hope our listeners will enjoy. Sample of the things we'll be covering today is we want to talk about the issue of parenthood, that is fathers on birth certificates. We're going to be talking plea agreements, especially in corruption cases. The finance bill, of course, which is on everybody's lips in Kenya. Appointment of ministers, we're going to try to touch on it. The issue about the SHIF Act and its unconstitutionality. Um, we also going to see if we'll touch on the issue of the face of Kenya, the provision in the constitution that says that appointments should show the face of Kenya in any government organization and such. We also going to talk about regulation of religious institutions. That is coming from the issue about the Shakahola, and also maybe, especially also on the issue of religious institutions and how they cause noise and violation environment. And also we are going to talk about, we're going to, you see, if you have time, we'll talk about the issue of the deployment to Haiti and also the blocking of media, these TV stations. Then, last but not least, we'll end with the issue of burial disputes. As you can see, small Daktari, we have a lot to cover, but maybe we'll try not to be too verbose on any issue, if
Too
we can,
detailed.
too detailed that is, if
Yeah.
we can that is. Anyway, so the first topic I thought we should start with is the issue of the removal of a non-biological father from birth certificate. I
Yep.
saw there are some number of petitions which have been accepted on the issue of
Yeah.
there are men who have found out maybe the children that they are bringing up, they are not their biological children, and then they have
Mhm.
petitioned the court to remove their names from the birth certificate, which
From the birth
the court have
certificates.
granted. But it's also an issue that brings up like what are the best interests of the child. So it's
Mm-hmm.
such kinds of things which are under Article
Yeah.
53. So you see
Yeah.
those kind of things they come up, and also those are the people who are removing their names from. And also there's also the other issue of the the parents, for example, the women who have children outside of wedlock. Yes,
Yep.
and they want the name of the father inside the birth certificate. You see,
Yeah.
in their law, it was saying that it has to be by consent. You cannot just put a man's name there. He has
Yeah.
to consent to his name being on the birth certificate.
Yeah.
But the courts have now said no.
Mm.
So, I mean, these are interesting things. What is the best interest of the child? Is the best interest of the child sound? And the court, I think, says the truth. The truth is what matters. But
Well,
yeah,
yeah, I mean, I one of the interesting things for me is that judgment, the recent judgment about that Kisumu man, it
yeah,
was based on interestingly Article 35, and
yeah,
Article 35 is about the right to information.
yes,
And the crux of the argument was that everyone has the right to have accurate information about them,
yes,
and the court was some sort of suggesting that the child has the right to have accurate information reflected on the birth certificate that this is not your biological father,
yes,
and you have a right to actually know your father, who is not this man, because those facts are very interesting in the first place. Because you look at this case, you see that they were work colleagues, I believe, and they were in some sort of an intimate relationship.
yes,
And when this intimate relationship had results or had fruits out of this intimate relationship, or or so the man would think, the lady made this gentleman to believe that the child proceed that was born during that period was his, until after some time when the man did a DNA test on the child, secretly found that the child was not his. And then, even in court, another independent DNA test was done, and it confirmed that the child was not his. And so, therefore, the court was some sort of thinking that if this is
yes,
not the right, is not the true father of this child, does this child have the right to have accurate information reflected upon in that knee? And at the same time, if the consent of this man was not sought in being recorded as the father of this child, do they have the right to actually be struck out? Because again, they also need, the man also enjoys the right to have accurate information about them in any form of office. And that's why, in the first place, the AG and the registrar of persons was sued, so that they can be able to effect that, so that any false information about this person. You've mentioned about Article 53, but one of the most interesting perspective is that Article 53 is one thing that did not feature in that judgment. The court did not seem to consider about whether it was in the best interest of this child, especially now that the father of this child is not even in the limelight, at least in the circumstances of that case. Wouldn't have been the best interest, but then again, the best interest of a child seems to, how far can it be extended? Can you extend the best interest of a child to a person other than the guardians or the biological parents of a child? Or is it that the foundations and the framework within which the best interest of a child operate is insofar as the father and the mother of a child are related? And it appears that this man is a third party out of this relationship, and whether you can extend those nini to them, maybe that would be the reason why the judgment was basically so much about Article 35. And the whole idea for me is,
yes. I
yes,
Sorry, Kenson. I think you've not been hearing me, but I had some technical challenges. But I get the gist of your argument on the issue of
yeah,
access to information, and it's the
yes,
truth. Actually, I saw even in another petition on the same issue, the issue
yeah,
of the information issue. It's also the man himself, the supposed father, also
yeah,
has the right to have his
accurate
information rectified.
information.
Yes, about him.
Yes,
And there's also some you should say like an unfortunate case of another woman who had a child with an expatriate, that is a foreigner. So and then when the foreigner wanted to process the citizenship of the child in their foreign country, and then you have to do the DNA test for you to confirm fatherhood, and then it came out that he was not the father of the child, and so he petitioned to be removed from the birth certificate. And
mm-hmm.
it also brought up the issue of that it's beneficial to maybe to the man, because you see, once you're in that birth certificate, it will also may come with also these kind of upkeep issues may
Yes,
crop up in the
custody
future. Yes,
maintenance and
yes,
those kind of issues.
yes, that they may crop up in the future. So the issue of the court has said like uh the men or maybe supposed fathers who are not the biological fathers of the children have the
Mm,
right to be removed from the birth certificate, yes? And also
yes.
the courts have said that the women who are having children out of wedlock, they
Mm-hmm.
have a right, or maybe they have a right to to indicate who is the biological father of the
Yeah.
child, even without the consent of the biological father. Yes. So
Mm.
those two things are agreed. So, but I think I told you earlier that I'd come across this issue about this issue of when these two things are there,
Mm.
then in a way they might prove what should we say? It is a disincentive. They might maybe in the future for people to be recording or to be saying that they have children. This is a problem that was there in South Korea, for example.
Yes.
And there is a decision that has come from South Korean courts, which was like in South Korea, the problem is people are not registering or are not
Mm-hmm.
they're not registering that they have had a birth because maybe
Mm-hmm.
the woman is maybe having the child is the product of maybe an adulterous relationship. You see, in that
Yes.
context, this
Mm-hmm.
child, the biological father, is not
Mm.
the same as the married partner of the woman. You see, so
Yeah.
in that case, the woman
Yeah.
chooses not to register
Chooses
this
not
birth.
to register.
Exactly. Chooses not to register the birth because it will bring in a conflict. And the father knows this child is not his, so even him, he will not go and register. He doesn't want that. He doesn't want that problem. So what the
Yeah.
courts have said in South Korea, they said,
Yeah.
then this third party, this person who was involved with this woman,
Yeah.
this man now, the biological father,
Yeah.
can now go ahead and and like register the birth. So
The
it's a
biological
reverse.
father now.
Yes, the biological father now can register the birth. It's like turning the logic on its head. You see, in our case, we think it's the women who are instigating, or maybe the female party who is instigating the registration. But in
Yes.
South Korea now, they're saying now the man can now instigate the registration of the birth. So it's like, will we ever get there? Maybe we'll get there. Maybe now with this kind
We'll
of
get
changes
there
in the
because
law.
I mean,
Yeah.
where we are headed now is that we are at the edge of now opening up to those disincentives
Yes.
of registering.
Yes.
Because when our lady recognizes that she is in a particular situation and then the biological father is not there and she is with another man who is not the biological, so she finds that the easiest way out is not to
Yes.
register.
Yeah, or maybe even if she's a mistress, she doesn't want to be known, and so
Yes,
maybe the counterparty to be known. So the easiest way is not to register actually. So instead, there's also a disincentive, or maybe an incentive not to register,
yeah.
like the one which is now facing South Korean society.
We are definitely headed there because I think one of the things that has resulted is that the 2010 constitution has been an all pervasive document.
Yes,
It's pervasive for the government, it's pervasive for individuals, it's
mm,
pervasive for everyone is
yes,
affected by it, and we have to live within certain uh, confines that have been imposed by the implementation of this constitution.
it's true. It's true. I was just actually coming across something today that
Mm.
is it? Yeah, it was saying like in France, when they get new major changes in their constitution, they
Yeah.
have like it's now thought, or maybe they say we are in a new republic.
Mm-hmm.
So in the same way you can say in Kenya post 2010 we're in a new republic.
Oh, we're in a new republic. It's a
Yeah,
constitution that demands very high standards from the people and what have you. And
yeah.
without those standards, living up to those standards, then you find that your lives are going to be affected for sure.
Okay. So the other issue that we wanted to run through is the issue of these corruption cases. There's been this interesting case, this like issue of the former governor of Migori, Honorable Obado, case of the anti-corruption cases against him,
Yeah.
and there were these reports of there being a plea agreement to
Mhm.
settle the 1.9 billion case by him giving up property that is worth 235 million. And they just wanted to know what are your thoughts on this kind of agreement, plea agreement. Do they constitute an admission of guilt? What are the implications on Chapter 6? If maybe you were to take such a plea agreement maybe as a leader. So yeah, what are your general thoughts? Because anyway, the DPP and the EACC are saying so many things that it's not a deal, it is only on the civil side. Okay,
Yeah,
let's we will never know until maybe the documents are tabled in court. Maybe they will also sign a deal on the criminal cases.
absolutely.
Yeah.
Absolutely. Yeah, I think right now, immediately those news came that there's been a plea agreement between Obado and the state. The EACC was very quick to say that was in respect of the civil case, and right now we are still proceeding with the criminal case as it is. But let's look into the aspect of what are the implications of an agreement. For me, it
Mm,
appears to be that in its very nature, it suggests an admission of guilt. Because before we agree on anything, we are saying, let's do so and then you get this in return.
yes.
You get this in return. Whether it is a civil case or a criminal case, the bottom line is that there is a form of agreement that you have agreed to certain things and you have admitted to certain things so that you can get this in return.
Mm,
And then the question then comes up to be whether a plea agreement has the same effect as a conviction or as a conviction would insofar as Article 75 of the Constitution is concerned, and especially to things to do with Chapter 6. And
yeah.
what I would be more interested to look into going forward is
Mhm.
whether these plea agreements have in any way affect the eligibility of the
Yeah.
leaders that are involved insofar as running for offices are concerned.
Okay.
If we can just oppose that with impeachments are all about
Yeah.
accountability. In fact, the Supreme Court in the Sonko decision made clear that point, that in fact, um, impeachment proceedings are neither civil nor criminal in nature, and
Okay.
they're just about mere accountability. Such that then, can we therefore look at plea agreements as accountability tools? That even if we don't want to attach any criminal or civil capability towards it, can we be able to attach any
Mm,
accountability lens to those plea
yeah.
agreements? And if
Yeah.
we can, then they might be as well be having the same consequence as, if not a conviction, in the very least, an impeachment fate might be facing these particular people. Of course, it is much worse when a plea agreement has been entered in a criminal case because it is a form
Mm,
of a plea. It's a form of a plea. It's either people take plea for different reasons, either to reduce the
yeah.
charges, to reduce the sentence. And one of the conditions, I think, just as you mentioned, is probably one of the things we'll be looking into is the plea agreement itself. To look at the plea
Mm.
agreement itself, and maybe from there we can deduce from it what we would like to see. But from a general outlook, I think that someone who enters into that plea agreement cannot meet the test of Chapter 6.
Because you are essentially saying chapter six is not about maybe the hard law. In a way, it's just like what is the moral compass? What is like the
Absolutely.
moral outlook on this person?
Absolutely.
Does it
Absolutely.
meet like some kind of a more and the moral thing is it doesn't
Yeah.
have like a high legal threshold just
Ah,
maybe
yes.
as a hard
Yes. Yes.
legal
Yes.
issue. Yes.
Yes. The Mumo
Okay.
Matemo case was perfect in that instance at the High Court judgment when it was saying that the test of Chapter 6 is that serious questions regarding your integrity have been raised.
Just
Those
serious
saying
questions.
serious questions are enough. You don't
You
need
don't need the
actually
answer.
we don't need an answer. We just need to raise serious questions about your integrity. But of course, we know the Court of Appeal just changed. But I do like how the Momo Matemo case had approached this issue about integrity, when they were they're talking about like Caesar's wife.
This is why.
It must be beyond reproach.
Yeah.
For you to be able to meet this particular nini. Of course, the argument has always been given about how do you juxtapose chapter 6 with the presumption of innocence, that everyone is has that right to be presumed innocent and what have you. But there have also been a jurisprudential development trying to delink that principle of presumption of innocence from chapter 6 insofar as limiting it to just serious questions about your integrity being raised is enough to impeach your character.
So I think in this case, if you take a plea agreement, yeah, you will be in very hot soup constitutionally, that's
Exactly,
what you can surmise.
exactly.
So it's not advisable.
It's not
But
advisable
hmm,
unless the only reason you're doing that is to escape jail. But if you are looking for leadership, Nini and what have you, most of them actually are like if you look at Obado, of course he might have future political ambitions, but he has already served his 10 years and what have you. So he might be just thinking about retirement and what have you. He just doesn't want to retire in a prison warden. Maybe he
true.
just feels like nini, but for those people who have political ambitions. But on the flip side, it might be something good for EACC. I mean, it's good to be able to recoup something from the public, for
Yeah,
the public benefit.
yeah. Plus, it's also self-judicial time.
Yeah,
Imagine if the case you were to drag for 10 years plus, I mean,
absolutely.
which is not unheard of in this
Mhm.
country.
And that's
So,
actually is the biggest argument in favor of plea agreements, that they save enormous judicial time
yeah, they save resources for everybody.
for
The
everybody,
person who is the accused
including
person,
the accused
the,
person.
yeah, they do save a lot of time. And I think they should be promoted in many cases. I don't know, but I also had I don't know. I'm not really too familiar with this anti-corruption matters, but I was just thinking out loud to myself, like, what is the nature of the civil cases? Who are the parties in those cases? In I don't understand how they,
Absolutely. By
it
the
doesn't
way,
make sense. Like,
whether were the parties to
or
those
DPP
civil
saying we
cases.
have a civil case, even if it's the EACC which has a civil case, it does not
Yeah.
make there's something that's not really making sense there.
Especially because ASECA
Yes,
provides that both for forfeiture of stolen public resources, misappropriated public resources,
yes,
and a jail term, such
yes.
that we are still getting. So why would you institute civ, and on what basis actually? Do you even
No,
have
I think okay, I think the council here. I think it's case of splitting hairs. What the EACC is trying to say is they're trying to kind of say they're trying to cover their back and say we did not actually enter into a plea agreement. But in actual sense, you see, in Kenya we do not have like a restitution under the. But okay, let me just stop there, not make any kind of statement that I may not verify. But it's
so,
let me say that my mind is
but
still
for
trying to
sure,
figure out.
that's a thing that they need to put us into the light. There's so much confusion about the Obado cases insofar as they are concerned about the criminal and the civil. Maybe we just need more details. And it's also an aspect of transparency and accountability insofar as prosecution of cases that affect the public are concerned.
true. I think
Yeah,
let's leave that for another discussion. Once we get down to the details and nitty-gritties of this issue,
we
then
can get back to it.
next time we will get back to this. So the other issue is on the issue of the finance bill. That's the what should we say? It's now the elephant which is leaving the room or is still in the room.
Still in the
So
room.
so that's the big issue.
Yeah,
There was a big scandal on the withdrawal of the finance bill, whether the president actually withdrew. Now he withdrew with reservations, saying that all the clauses should be deleted. And then the speaker replied and said when he submitted to parliament that now all the clauses have been deleted, so there is nothing to debate. The bill is essentially dead. There's no
dead.
bill anymore.
Yeah.
So, what are your initial comments on the whole issue, the whole scandal surrounding the repeal, or what should we say, the cancellation of that
Yeah,
bill?
yeah. Interesting enough, when it comes to this type of legal issues, words are very critical. The words used, like the words withdrawal, have serious legal ramifications connected to those words which cannot apply in these circumstances of this case. Starting with the word withdrawal, the finance bill, having reached the third stage, could not be withdrawn, not by the president, not by the mover of the motion, because the standing orders do provide the framework and the standards of withdrawing a bill, where the mover can move the bill at any time before it has been passed. Once it has been passed, only two things can happen, and this is contemplated under Article 115. The president can assent to
Mhm.
that bill, or it can return, or it can actually refuse to assent to that bill. If he
Mm,
assents to that bill, it becomes law. If the president refuses to assent that bill, then he cannot sit on it. He must
mm,
return it to parliament, but return it with reservations why he has actually refused. Because one of the things that we must appreciate is that Article 94 of the Constitution, to read together with Article 1, fully vests legislative powers on Parliament. The
yeah.
president just exercises a ceremonial role insofar as it is concerned, and that is why actually we had that aspect of vetoing presidential powers. That actually the president's refusal of sending to a bill does not per se mean that that bill is not going to pass into law if Parliament still is insisting on doing that. During his speech, the president alluded to the words withdrawal, and I think that is what made so many people attract attention and what have you. It was just semantics. The word withdrawal does not fit in the circumstances of this case, and it could not be done. So what we can speak about is about the repeal or cancellation. In fact, even repeal is a whole different issue, because repeal, you have to use another law to repeal to repeal it.
Yes.
A law in itself cannot repeal itself. It can just cancel, or it can
Yeah.
just terminate.
Mm,
It can just terminate, or it can just be made to be a vacuum, which is
yeah.
exactly what they did. The
Yes.
president technically was saying that delete every clause so that there is nothing to pass, as in you have just disintegrated it, Nini, and you have just given us a vacuum. And the president returned it. The issue was whether the proposal to delete every clause actually amounts to a reservation. Of course,
Yes.
this is something that Parliament did not want to engage in. One of the most neat aspects we have had in our democracy is that we have a Parliament that is fully constituted by the ruling party, and so there is there is little to no disagreement between the executive and parliament, so you don't expect any sort of vibrance in terms or in any sort of vibrance in terms of disagreement between the two, because I think we could have probably been in a position to understand whether these reservations, whether the proposal to delete every clause met the threshold if it was met by some sort of resistance from Parliament itself. But you can see
I think
Parliament was
also,
very ready. Yeah,
sorry, I think also you see the issue why Parliament has to go along. Number one is also there's also an issue about that the finance bill is actually a bill that is instituted and drafted by members of the executive. Really, it's
exactly.
not.
Exactly. It's a treasury bill actually, and that is a direct linear of the Constitution. Chapter 12 actually says that it emanates from the treasury.
Yes,
That brings it to Nene. But the point I was trying to make is actually not even connected to the finance bill itself. It's
okay.
connected to the issue of reservations
Hmm.
of whether the parliament could in any way engage, because Article 115 actually sets out in clear terms what parliament should do once the president has refused, because the first thing they should do is to consider whether they accept the president's reservations. If they do, they can make those necessary amendments to reflect the president's reservations. If they don't, then they reject it, and if and the speaker is actually required to resubmit it back to the president within 7 days. And if the president refuses to assent to that bill, then it becomes law. In fact, interesting bit, the law does not contemplate a second a second uh, refusal by the president, such that, for
Yeah.
instance, can you imagine this scenario? The president had 5 issues that he had reservations with. He sends it back to Parliament. Parliament only accepts two. The president is not allowed to refuse to assent to that law because his 3 previous reservations were not contemplated or were not catered for by Nini. If he does, then that bill will become
Law.
law within the lapse of 14 days.
Yes.
So, in this case, I think we did not get to that point of getting into that crisis, because Parliament readily accepted. The
Yes.
High Court had earlier on reflected upon the scope of reservations in a case that I think it had involved COD. I think it was during the time of issues to do with and again, I think it was about the finance bill, I think 2018 or something. There was a law that had been passed. There was a law that had been passed by parliament, and the president had issued reservation, and there were questions of whether the reservations that the president had issued at that particular time did meet the threshold of reservations um uh in the
Uh,
in the f- in the first place.
okay. I would also say, you see, also there's no much. There was no much friction against the withdrawal, or let's say the deletion of the clauses by anyone. So I think nobody was looking. Nobody
Exactly. Nobody
actually
was concerned
interested in the
about that.
constitutional questions. So
Exactly.
I think
And
people
that's why
just
I'm
wanted it
saying,
to come on.
and that's why I'm saying that's maybe the loss that we are at right now,
Yeah, yeah.
because Parliament was ready to run by the tune of the presidency. Was just imagining if we had a scenario like and maybe something we could try in future in Kenya. I don't know how much it would work. You see, like the USA, once they elect a democratic uh president, they try as much as possible to have a Republican Congress, right? And
Yeah.
some sort of establishing some sort of checks and
Balance.
balances and what have you. But look at ours. It's the Kenya Kwanza president, and the majority are the Kenya Kwanza. So you expect them to be in the same tune and what have you, even if we had that. And so there was no friction. In fact, it was as good as having been made in the presidential speech that the finance bill has died. We actually
There's
did
no
not need
friction either way.
parliament. Yeah, we did not actually need parliament was just a footprint, just to stamp,
Rubber stamp.
just a rubber stamp to put it into record that you have already done because it was as nini, but it passed that way. Yeah, and we escaped a constitutional moment that could have engaged Article 115 in its full breadth. However, actually, there is a petition that was filed by Ochieng Oginga. I don't know whether it's likely. I mean, our courts decide to be very technical when it comes to policy issues. So I'm suspecting now that the bill has already been declared to be non-existent. At this point, the court is likely to say that the matter has now become moot,
Yeah,
and it
it
is
is a moot point.
unnecessary. It's unnecessary to determine anymore
Yeah.
that particular issue. But of course, now we have in deeper
Speaking
problem
now
because
with finance issues, let me just cut you short, huh? That
yeah,
now we can to move along. I think the last time we were on this podcast, last time we were talking, we had actually postulated on the issue of there not being any finance bill, that maybe we should not be enacting finance bills every year, and what would actually happen. And what we postulated has actually happened. We do not have
yeah,
this year's finance bill. And today, there
mm-hmm.
has been a judgment that has been released that actually even invalidates last year's finance bill.
Last years,
So
can
we
you
do not
imagine
have
that?
we do not have two finance bills, and it also even touches on another thing we also discussed, the issue of having specialized courts to deal with government
Yeah,
policy issues. Because you
yeah,
can imagine, this
yeah.
is like 1 year after people have already there's like they're already living with whatever provisions are there. All the systems have been configured to reflect that system. It's like a legitimate expectation is going to continue or something, or we can some kind of a legitimate expectation or something of that sort. So where does this leave us? Like we are in some kind of what should I say? We are actually tumbling and tumbling, and now we are tumbling so much. I don't know.
We are in a
We
tumble.
are both, yeah, we are in a tumble. We are dizzy. We are almost falling over. So, like, in your thoughts, kindly entangle us, and so let's see
I
how
mean,
where we can get to.
one of the most interesting implications of today's Court of Appeals judgment is that President Ruto effectively does not have, and this also makes it an even more complex issue. That President Ruto campaigned on a bottom-up approach. He calls it the better policy of how he is going to run his government,
The plan,
the plan of how he's going to run the government. And every government's plan is based on budget. I mean, there has to be a budget that is in a place to support that. Now, we have two problems here. The 2023 Finance Act, which is just the foundation of how the government collects its own money, has been declared unconstitutional. The 2024 Finance Bill, as we have just recently discussed, is no longer in existence. It has been deleted. Every clause has been deleted, which leaves us with the Finance Bill of 2022, or the Finance Act of 2022, which was in the reign of President Kenyatta, a whole different reign. I was just looking at the news the other some few moments back. One of the implications is that, for instance, VAT on fuel is no longer 16%; it is now 8%, going back to the 2022. Number two, the minimum taxable wage, when you are talking about things to do with 35% and what have you, now it's now back to 30%. There's been a serious there's been a serious change of balance going back to
Mm,
all the way 2022. You must also remember that the Finance Bill and the Finance Act, consequently, of 2022 was at a period of campaign period, and President Uhuru Kenyatta was at the moment trying to campaign for Baba. And so, for the time, because Baba was being associated with the government, it was a very, very friendly it was a very
many
friendly
subsidies.
finance act. The subsidies were there. They were trying to show the Kenyan people how they are wary of the things that they are going through. And it is now what President Ruto has been returned to. It remains a real legal question of obviously whether the government is going to allow that to happen, because a declaration of unconstitutionality has the effect of reviving the law that was purportedly amended by the now repealed, and not the repealed, by the now declared unconstitutional law. But
Mm.
of course, we know how KRA operates. Do you think that, or do you think KRA or IPRA? One of the things that has been, you remember that IPRA was just escaped contempt of court by a whisker in the 2023 finance judgment at the High Court. They just narrowly escaped. Now, the question is right now whether they are going to revert to the 8% VAT on living fuel. And so we expect that there will be an announcement of new fuel prices as soon as possible, or the government is going to proceed to tax on the basis of the 2023 Finance Act. Now there is when now we get to another conundrum. The conundrum is courts have always emphasized this idea that voluntary taxes are non-refundable. In fact, that is one of the things that the Court of Appeal even emphasized today, that never mind that you have been taxed under the 2023 Finance Act, you guys cannot claim a refund of those particular taxes because of the presumption of constitutionality. And of course, they said that they gave another technical argument that this issue of refund was only raised at the Court of Appeal and it was never raised at to the High Court. And now the question then becomes, if the government is not keen or ready or intent to return to the Finance Act 2022 because of the serious implication that comes in terms of revenue collection, and you remember that now they're talking about austerity, we are in a very big problem in terms of debt collection and what have you, what will happen if the government continues to levy or to collect taxes on the basis of the Finance Act 2023? If someone goes to court, what will happen? We have an history of serious disobedience of court orders, especially when it affects policy. I've seen
Mm.
Kimani Ichung'wah decrying today that this is judge-made law. I mean, the government is seriously affected, and I would sympathize with the government that the today's judgment has serious policy implications.
Serious
Uh,
one.
Serious policy implications to the government, and I wouldn't be surprised, by the way, if the government the judgment
Mm.
ignores the judgment, because you cannot expect them to go back to things like VAT,
Yeah.
8% on fuel. You cannot expect them to go on the minimum taxable wages, percentages, and what have you in those particular instances. But finally, I
But
think
but
they should be able
Kenson,
to fast track.
just to stop you, there is also the issue of taxpayers themselves rescinding or remitting this money. The FKE last time when the housing levy was declared unconstitutional,
Yep.
it advised its members to not remit the housing levy.
Yeah.
So if another organization or maybe the same organization were to advise its members who remit various levies and those who
Mm-hmm.
are promulgated under the Act not
Mm-hmm.
to do so. Kind of policy challenges that now we are expecting from this kind of judgment, because now it's 1 year post the enactment of this act. We don't know we don't, because the financial year of the government has already begun. We don't know if there can be another finance act to be, if it can be enacted at any other time, and how it will be implemented.
Yeah.
So, what do you foresee for the future? Like, at least the kind of policy challenges you're going to encounter there, the kind of friction between employers and just taxpayers
Yeah,
and the CRA.
definitely. Definitely. Those are the challenges that you are likely to face right now. To be sure, this is not the first time you have been put in a conundrum. We are in a conundrum of the NSSF as it is right now because of the recent developments that happened with the NSSF. To the best of my knowledge, I think people are still remitting
Yeah.
NSSF just as it was before the effects kicked in. There should be a serious conundrum once FKE, especially because I know it's something that it's going to do. The Federation of Kenya Employees, something that it's going to do. I expect something to do with quotas, and they may also come up to say that they are not going to um, remit these taxes that have been. But what I foresee that is going to happen in this thing, it's something I've already predicted, is that the Supreme Court is likely to reverse the Court of Appeals judgment, at least insofar as there are so many
Reverse or
issues.
initially suspend the judgment.
Yes, exactly. They will issue conservatory orders. They issue conservatory orders to suspend the judgment. You know, the Supreme Court has turned out to be the institutionalist court these days. It has become the court of appeal that was in terms of preserving because um I think for me this judgment serves especially no utility value at this point. Even what if the Nini had already been actually passed, the Finance Act of 2024, it would be just a cosmetic judgment, an academic judgment, especially because the court is emphasizing that you cannot claim a refund of the taxes that have already been paid. So, given those complications, I foresee a scenario within which that the Supreme Court is likely to stay the judgment. The judgment itself is extremely liberal. I can assure you it's extremely liberal in terms of even its understanding of Article 165. I am someone who personally, I do recognize the role of a judiciary. I usually say I can live with an expansive judiciary more than a predatory executive. It is much easier. It is much easier for a democracy to live that. But again, I have certain limits within which an expansive judiciary should go. The Court of Appeal today said that actually Article 165 of the Constitution of Kenya extends to the jurisdiction of High Court over policy issues as well. I mean, there is nothing that stops the government from considering policy issues, which is in a way affects serious doctrines of constitutional law such as avoidance, political question doctrines, and those issues that are critical to the running of any republic, because it's a thing of separation of powers and what have you. Such that if the Supreme Court is not going to do that, to reverse what the Court of Appeal has put us into, we are looking at two competing interests in which citizens are not ready to continue to remit taxes to an unconstitutional law, and the government, on the other hand, is not ready to go back to the 2022 Finance Act, which affects several areas of the collection of taxes, and therefore we expect it to be based on who has the final say, who can have the last laugh. And that's why I'm saying it's very much dependent on the government willingness
Okay.
to revert back to the 2022. If the government intends to proceed with the Finance Act, I see it continuing for a while, unless now we go back to the protest of the Gen Z and what have you.
Okay, staying on that still high note of the unconstitutionality of acts, there's
Yeah,
another act which has been rendered unconstitutional, major
yeah,
act of this
yes,
regime, that
yeah,
is the Social Health Insurance
yeah,
Fund Act and
yeah,
other acts which are closely related, the Digital Health Act and this other act which relate to health, which have now been rendered unconstitutional. You
yeah,
have just talked about the expansive judiciary. In these
yeah,
acts, when they were being rendered unconstitutional, the judiciary actually said that it is trying not to. It's actually, in essence, it was just saying that it is trying to be avoided. It is not going into the questions of whether this thing is bad or good. It's not going into the
yeah,
policy issues. It's just
yeah,
looking at one major issue, which is also
yeah,
touched on into the unconstitutionality of this Finance Act, the
yeah,
issue of public participation.
yes.
This is
Uh,
a big dragon in Kenya that is eating everything. What is public participation?
oh,
What is the
and
scope of this
today
thing?
things have changed. I'm telling you, forget even about SHIF. Today things have changed with the Court of Appeal, and I've actually just tweeted right now. I'm thinking that one of the things the Supreme Court is likely to say about the Court of Appeal today about its approach to public participation is that it's likely to attack them. It did recently. The Supreme Court, I think they're not fair. We want lower courts not to be excited of being confronted by a jurisprudential moment, to think that they have been confronted by a jurisprudential moment. I think this is a very unfair comment to the lower courts, especially the
No,
Supreme Court,
everybody wants to be the star.
saying that of the of the Court of Appeal. You guys are so excited that you are confronted with a constitutional jurisprudential moment, and
They want to shine.
the aspect of public participation. The SHIF judgment is a judgment that's tried to strike a balance between the government and between policy and the judicial role, in the sense that it said that we're declaring this act unconstitutional, but we're giving you time to regularize. That if you do this within 120 days, you'll be up and going with your act. Now, the only challenge is that you think that government will do these things. You see, sometimes when you give government that opportunity, they think that you have actually allowed them to continue with what they're doing. We have had a scenario, for instance, of when Section 295 and 296 of the Penal Code on robbery with violence were declared unconstitutional. When they were declared unconstitutional, they were given some 18 months to regularize. To date, that has never happened. And so the question has always been, once the judiciary actually walks this temptation of trying to be cool with the government and giving them time, what should happen within those 120 days? Do you need to go back to court, or the effect of declaration of unconstitutionality proceeds from that particular aspect? So we are still waiting for the 120 days to see. But from the previous instances where the government was given a time to regularize and they never regularize, they have always continued with the law as before regularization, as if nothing happened. And it's a trick that the judiciary plays on itself, because once you do that, unless you have already said that unless you have already said that if you do not regularize, and then a declaration will come into effect, you need to go back to court to seek more consequential orders, because a declaratory
No,
order,
in the SHIF,
yeah.
in the SHIF judgment, it says if they do not they do not make those
So it is
amendments,
very
or
express that in
it's
terms
very
of how
express
it's
that
that
yes,
if you
once
don't regularize within
it becomes
120 days, then it becomes
null and void. That's what it says.
anality, then that's one the judiciary played safe. It played safe without leaving it open, because once you leave it open, you have to come back to court and what a view. Probably this time they may take it more seriously and take the 120 days seriously, although it's not something easy as well, especially when it's a public participation issue. And when I'm saying it's not easy, it's what the Court of Appeal has introduced today. The Court of Appeal has introduced something today where it's saying you must give reasons why you have rejected this and why you have accepted this. And especially when there is a bulk of things saying A and you go for B, you must give serious reasons why you have gone for this. And I think, Lucas, you and me have had the opportunity and chance to engage with procurement disputes. You see, procurement dispute, one of the issues that is required is that you must comfort the losers of a bid. That once you have given the winner the lowest evaluated bidder, you must tell these other bidders, guys, I give this one because of this, nini wewe nilikukata because of this and this. You do understand that it is a laborious task by itself when the procuring entity actually does that. When it is doing that, and it is usually a few numbers and what have you, and it attracts
Yes.
several disputes, even when it is only a few bidders who are expecting to be given information why they were rejected and what have you. Now, Parliament has been given that task. It has been said by the Court of Appeal that Article 10 requires you to do that. One of the things that SHIF has attracted is that attracted a lot of animosity from the public, such that even besides what was being directed by the SHIF judgment alone, the Court of Appeal judgment of the Finance Act has heightened the nini, which even makes it difficult to do that within 120 days. Because how are you going to take up views, respond
Traverse the
to
whole
the
country.
views, And then, and one of the things I'm seeing, especially that is going to happen, is that you're going to see some, we're going to see some either civil society or nini that or donors, even donors who are going to be sponsoring public participation so that you can overwhelm parliament. You just have, and by the way, nini, people don't appreciate this. Article 118 about public participation. Public participation is done by the committee that is responsible. So it's only even actually a few people because the committee is roughly of up to even 11 members
Yes.
and the secretariat that is expected to run the views of a whole 50 million people if they decide to do that and to come up with a report. It's something. It's
it's
something.
it's it's
It's something.
mind-boggling, and I can something just has come up in my mind, and
Yeah.
I think we should also engage with this question because it was engaged even in the judgment. But I don't think people are pushing it to as far as it should be, because yes, the courts are saying that public participation is to give effect to the sovereignty of the people. But what is the balance between the sovereignty of the people and these people having given away some of that legislative power to MPs? Are we making public participation another legislative column,
Yeah.
like another
Clearly,
forum?
we have reduced the meaning of Article 1 to that the people may delegate, because once you bring public participation to play a critical role at the delegated level, then it overshadows the delegated powers.
Exactly. So yeah, actually, are we in a way you can support the majority leader and say the judges are making law that is
Yeah. And
infringing
that's why I'm
on the
saying
sovereignty of
such
parliament.
things. The Supreme Court is like. By the way, one of the other things that the Court of Appeal introduced today was saying that amendments done to a bill after public participation are null and void because you cannot subject those amendments, which affect the whole
I
legislative
think
process.
yeah, I think that is also what you're saying. That is that's like extreme judicial like
Because
judicial overreach.
because even at the committee stage of where the whole house sits as a plenary, as a committee, they actually introduce amendments
Yes, exactly.
to a bill at that point. They're saying, I propose the nini of this and what have you. Of course, it's something admirable, but again, the judiciary also forgets that politics is not as good as law.
Mhm.
Sometimes you think that public participation is only going to give good public
Good. Yeah.
views.
True.
There are some people who are going just to bring public views that are meant to frustrate
And
and
derail.
to derail the lawmaking process. Especially, you can imagine when a lobby group hears that the parliament intends to make a particular law that is going to affect them, that lobby group is just going to ensure that it lobbies as many people as possible
Yes.
to be able to participate in the public participation against this bill
True.
and to overwhelm. Number two, the finance bill, for instance, if we are going to proceed with this approach, it has strict timelines within which it should be enacted.
Yes.
There are strict timelines which are pronounced by the same constitution, the court. How are you going to ensure those nini are done? And you see the way we do public participation in a very brief time here, like public
Yes.
participation inakwanga imefunguliwa. Right now, you might even need 6 months at this rate to carry out
Yeah. Yeah. And I agree with
public
you. And
participation.
it's going to be to bring, and also that issue of giving reasons, because if somebody assumes or says, oh, this reason that you're giving me are not satisfactory, they go to court and say that
Exactly. Actually,
you
that
did not
one
give me good
opens a
reasons.
whole can of worms
Another
because
kind of worms.
reasons, once you say the word reasons, you bring in the justifiableness and the open democratic aspect of it.
Exactly.
The moment
Like
you
what?
give me a reason, you have opened up to judicial review.
Exactly.
And I'm just saying this cannot be a good reason.
Yeah.
This cannot be a
Okay.
good reason
Okay. I
for
think
it.
on those two issues, I think we can ventilate for 2 hours, but let's leave it there for just our food for
I'm so
thought
sure
for
the
us.
Supreme Court is going to reverse that. They
Yeah.
have become
Otherwise,
the institutionalist.
yeah. Okay. So the issue that another issue that just came down from the whole finance bill fallout is the issue of the ministers. We know that the whole cabinet is dismissed, but there is an issue that is pending on the issue of the attorney general, and also the issue of kind of security of tenure. Some people say, of course, the president has the prerogative to hire and fire them, but some people also say that the constitution also gives even ministers safeguards against just one day a president waking up and being fired, because
Yeah.
they will go and say That was what used to happen in the old regime. Now we are in a new regime. We need our constitution protects us. What do you say?
Absolutely. I mean, there are sometimes constitutions has some internal contradictions here and there, but of course they are all covered in Article 2.3 that the validity of the constitution is not to be put in question. Article 152.5 provides 5A to be specific that the president may. The word may has been used to suggest that it is only suggestive. It does not impose, at least in many occasions. There are some instances where it might infer something else, but here is that it is suggesting that the president may, at his own will or preference, actually dismiss a cabinet secretary. Even before the 2010 constitution, this is something that we recognize as the pleasure doctrine, and it has been accepted in very many places that in very many very many jurisdictions that the pleasure doctrine operates in a presidential system where the president operates at a free will, and it's a principle that is entrenched especially in running the government. You don't want to encumber the president so much such that he doesn't have a free will or a free hand to run his government. But the framework of the Constitution of Kenya seems to have some sort of scrambled this idea of pleasure doctrine. First, even from the appointment of cabinet secretaries, they have to be approved by parliament. They have to be done all this particular process. And there's actually an argument that was being done about whether you should be able to actually seek even the approval of parliament before dismissing a cabinet secretary and what have you. But of course, now people are saying that that is covered under Article 152.5b. insofar as the impeachment, for instance, like the one we went for Linturi removal, where there's been a violation of the law and what have you. Courts have had an opportunity to engage, but insofar as governors are concerned, it has been very explicit that they do not enjoy the pleasure doctrine, that they must give satisfactory reasons. And now it takes me back to the point of where sometimes the constitution may be contradictory, is Article 236. Article 236 provides about the security and the protection of state officers and public officers. And it is saying that they shall not be subjected to victimization and they shall be accorded a due process. And then the question is, does the president willful dismissal of office of an officer from office actually abide with Article 236? These guys, at least, I'm not sure with especially the generalization, and this is actually what brings us to the aspect of reappointment. These people, once they were fired, could one of them actually raise an issue that actually you generalized us? You said that we are, after doing an appraisal of our performance and what have you, could it be some of us were performing well, and that's probably why you reappointed us into office, and it is some others who are not performing well, those ones that you locked out from occupying office or what have you. It happened in 2020, I think, when Kionjori was dismissed from office by President Uhuru. He was never given reasons. I thought he would go to court. He never went to court to be able to look into that thing, to test about the scope of Article 152.5a, whether it should be read together with Article 236 to give reasons as to whether they are valid in the first place and what have you. But so far, it seems that it has been accepted that the president can dismiss at will the cabinet secretaries. The only question probably that we could be having is about the Attorney General, because the Attorney General is not contemplated under 152.5a. And that's why even the president himself said that he's dismissing the cabinet secretaries under 152, but he's dismissing this AG under Section 12. But now the problem with Section 12 is that it sets out specific grounds within which an AG can be removed from office. And for me, the mere articulation of grounds for removal from office, now this one without any degree of doubt, presupposes the application of Article 236, because Article 236 then must come into place to protect this person. Probably one of the weaknesses that we have in the Attorney General's Act, or even the Constitution itself, if you look at these important offices of them, the DPP, you have a framework for removal, you have the framework for removal of judges and the Chief Justice, but we don't have the procedure for the removal of the Attorney General. I don't know whether it's because he sits in the cabinet or what have you, but for sure he's not among, because even courts have been able to delineate the specific differences between the Attorney General and cabinet secretaries and What have
Yeah,
you?
so the Attorney General occupies this space, which is like a quasi cabinet secretary. He's a civil servant, cabinet secretary.
Yes,
He's hanging there in the balance.
yes.
So that's
Is a
why he's
constitutional office on its own that has
exactly.
been established because Article 154 establishes strictly the offices of the Attorney General and how is Nini, which is a little bit different from cabinet members and what have you. I can't recall quite well whether there is a petition that has been filed. Probably it could have been filed if Muturi did not find himself back into the cabinet. But now that he's in the cabinet, he wouldn't even entertain. But you know, the one of the interesting bits, yeah, of this
Yeah,
constitution is that a public spirited citizen can
he
go
can
out
achieve
there,
a lot.
to file that case that the AG was not legally
Yes, yes,
removed from office,
yes. Because of course the constitution,
and
what
they were left
was
standing.
yeah,
Yeah,
was removed.
and they were
The
left standing.
yeah the other issue.
Yeah,
But I don't think it's an issue to do with the appointment of ministers. It's just the issue of affirmative action. I think this is one of the last issues we'll deal with today, the issue of
yeah,
the face of Kenya. This is an issue that is, well, maybe it's not yet as live, but in the future, I personally foresee it as being a live issue. But it maybe right now it's just brewing and brewing and stewing. So this issue of the face of Kenya, what does it really mean, and what is the extent of the face of Kenya, especially not in the because of course the appointments in the cabinet have to go on the issue of the face of Kenya, but we
yeah.
have had these issues of the KRA when it's hiring. We're told these quarters that you should have representation according to what is in the census. That is essentially a quota system. If you have been following international news, you would have seen there have been protests in Bangladesh of a quota system
Mhm.
for the children of, or the children, not even the children, the great grandchildren of freedom fighters, for example. So they were given quotas on this they for employment into the civil service. But now these quotas have been scrapped by the Supreme Court in Bangladesh. So what do you think about the future of this so-called affirmative action, which is like ethnic based?
But though
What do you,
at some point, I remember one of the very first few petitions that were filed was, if you can recall, there was a petition that was filed the Supreme Court, that the Supreme Court was not two-thirds gender compliant before the likes of
yes.
before Nini. And one of the judgments that was issued, I mean, not even one of the judgments, but the judgment that was issued, and the likes of the DCJ Mwilu were there, were talking about the meritocracy of the Supreme Court sometimes can justify. Remember, Article 27, which provides for for the affirmative action, is not an absolute. It's not an absolute right. It's just that it is desired. It is desired that we are going to look into these issues. But that binding precedent from the Supreme Court didn't emphasize that there are some instances where we are going to emphasize meritocracy over
Yes.
uh, meritocracy of affirmative action sometimes, provided that there is no form of negative discrimination that is informed by rate. That was based on about gender. That was based about gender. But what about the ethnical considerations and what have you? The test
Mhm.
doesn't really much change so long as it is affirmative action for whatever reason. So it is on basis of marginalization or on the basis of on the basis of gender. But what I see from what the Supreme Court had suggested for me is that it is a two-tier test. That first of all, the mere appearance of more of one group over the other group, which is vulnerable, does not in itself suggest that affirmative action has been trounced or has been rejected, unless you show that actually the affirmative action option was also slightly as qualified, and the job itself does not require serious meritocracy that because we have that aspect
Mhm.
of what do you call it, some sort of standardization, where if this person is nini, then they is of this and then remember before actually the system was changed, even of KCSE, of joining campus. I think there was a big grade for given for boys and then girls. It was also a form of
Yes,
actually affirmative action. It was also actually a form of
I
affirmative
think it
action.
still exists.
No, right now it doesn't exist. At least by my time, it was an equal footing that everyone who gets a C plus. By
Oh,
my
okay, yes, true,
yes,
yeah.
it's brought that nini. But
Yeah, that's standardization.
yes, that's the standardization. But in Kenya, I think it should be case by case analysis. It's not everywhere. It's not everywhere that you are going to. I don't know whether the current um, nominated cabinet actually meets the threshold of the two-thirds gender rule, and of course, I think courts have excluded the secretary from the count of cabinet secretaries. But I think he has nominated quite a
Yeah, I
few
think it will
ladies,
meet.
quite a number of ladies in this current but it has never, even the previous, they just disbanded cabinet. It did not meet the two-thirds gender
Okay.
uh gender requirement, and it's because that aspect of meritocracy, that affirmative action itself is not an absolute principle that must always be adhered to by fire or force. It is only
Yes.
when it is possible, and I think it's a fair
Yeah, it's a fair,
analysis
yeah, analysis of the
of it.
issues.
Yeah.
Yes. Okay. I think now we can come to a final issue. I'm debating whether we we go on deployment to Haiti, but I think we can touch on that briefly because it's something that has already happened, and there are cases on the deployment to Haiti. There was a lot of talk on the issue of deployment to Haiti of the Kenya police.
Yeah.
The government had been really delaying on pulling the gun on that issue, and but it finally went ahead and did it. So, but you have made some few comments on that issue, and just give us a brief overview so that we can wrap this up.
Yeah. So the thing is really article there must be 241
241.
of the constitution that deals with 240 basically. Article 240 that deals with the national security organs and what have you. Justice Muita thoughts were that the National Police Service is not one of the bodies that can be deployed uh, outside Kenya, at least not through the National Security Council and Article 248 of the Constitution. It should not be allowed for them to be deployed outside Kenya for any form of mission.
Yeah.
And it based this on the definition of the word force, that Article 248 refers to the deployment of forces outside Kenya. But for
Yeah.
me, I did consider that the whole of chapter of the whole of that chapter on national security uses words very critically. There are words to do with security organs, and the security organs are the forces, which appears as national defense forces and foreign forces. And then there's services, and then of course the aspect of service we don't have any issue with that we have the National Intelligence Service and the National Police Service and what have you. We do know that from the CKRC reports and what have you, the idea behind renaming the police force from police force to police service was just to make it a service, a huduma, not to
Yes.
make it
Not a force.
a force that makes it and what have you. But there are some sleep errors. This is what I call sleep errors that happened in this type of when the constitution was being made in this particular instance, because now Article 248 speaks about the deployment of forces outside Kenya. For me, I think one of the reasons why that word forces refers to the national security organs as opposed to the Kenya National Defense Forces is, first, immediately after you see the National Security Council approving the deployment of national forces outside Kenya, the immediate provision says that it can approve the deployment of foreign forces in Kenya. Now, for me, it would be an absurd that if the word force was to be limited for the purposes of our own forces to be only about uh,
Defense forces.
defense forces, it would mean that even the ones that we are allowing in Kenya are also limited in the same way, which is something I don't think that the framers of the constitution would have intended in terms of limiting it in that particular particular way. And then number two, Article 240 is a general provision, and the rule of constitutional interpretation is that a general provision is to be interpreted generously. You don't interpret a general provision in the narrow, strict sense that you would interpret a specific provision, which is probably the good conversation you could have if you are talking about the deployment of the military during the protest and what have you. But in this particular case, I think for me that was a very narrow interpretation. It was a very narrow interpretation of the Article 248 by the High Court, especially again because of Section 6 of the National Police Service, which gives a whole set of different reasons that can allow the National Security Service Council to deploy the National Police Service, And the mere fact, because one of the arguments that was given by the National Judge Mita is that the National Police Service actually does not have the right or the power to deploy police services outside Kenya and what have you. And that's why I thought that the aspect of Section 6 actually, even though it is different, given for different reasons, waters down that argument that it cannot, the National Security Council cannot actually deploy. And then lastly, it is the aspect of Article 1, Section 107 and 118. I remember in those petitions, it must be the Ekuru Court petition that was seeking to declare these provisions unconstitutional because it was saying these provisions were contrary to Article 248, because the crux of the Ekuru Court petition was that at no circumstances, at no point, not even reciprocal arrangement, can the National Police Service be deployed outside Kenya. But the court rejected that argument, of course, and it was saying that there can be reciprocal arrangement. And for me,
this 81 was not a reciprocal arrangement. That's what the court is saying.
The Haiti was not a reciprocal arrangement because they were saying again there was not even a legitimate government that was at the time that could have reached. This thing came from the Security Council, not from the national government of Haiti and what have you. But for me, the fundamental point was that the mere appreciation that there can be reciprocal arrangement, which can result to the police officers leaving Kenya, then waters down the argument that at no circumstances you can deploy police forces, police service outside Kenya. So, but in any event, he navigated the scenario. I don't know whether it was appealed. I think the judgment was appealed, but the president, of course, found his own ways. And as we speak, we are just having a very academic argument because the National Police Service is already qua ground, as they would say.
Yes, and they reportedly they're very successful.
Yeah.
So I don't know. I think maybe on a radical vote, maybe the judge would have first gone ahead and declared those sections 106 as unconstitutional.
Yeah.
Then gone ahead and said that it was still unconstitutional to deploy them. So he first declared the National Police Service, those sections of the National Police Service Act unconstitutional because they are not mirrored in the Constitution.
In the Article 240.
Yes, as a part of the rules of the National Police Service. So you first declare those ones unconstitutional, then you declare this action.
Yeah, I think that is the loophole he left them to exploit.
Yeah, he left that loophole, and then the whole argument now is watered down. Anyway, I think we have had a good discussion. I think there was so much to cover. It's time which is always short.
It's always.
Yeah, so thank you so much, Kenson, for your insights and for your discussions on these various issues. And we look forward to more. To doing more of this. I think every time I usually think that the issues will be exhausted. They will
you can never exhaust these things.
it's like they're always coming up with new ones, so many. It's like a mountain now.
There's so much.
There's so much. So thank you so much for even giving us your time.
Thank you for inviting me, and I'm looking forward for more discussions into the future.
See you next time.
Right.